those obligations in terms of the Bill of Rights. So what we've done, we've asked the question, how does the Bill of Rights apply? And we've looked at the two ways, and we've said direct and indirect. Then we've looked at the relationship to which the Bill of Rights apply, and that is vertical and horizontal. Then we've parked indirect application. Now we're looking at direct application. Who is protected? Who is protected? Natural persons and depending on the nature of the right and the nature of the juristic person. We definitely have to find out whether these are nice sentences. I think we stand a chance. Okay. Then what we have to do, or what we did yesterday, is we looked at who is bound directly. In other words, who has a direct obligation in terms of the Bill of Rights. And we looked very specifically at state parties, and we looked at the legislature, the executive, the judiciary, organs of state, and we said the test is a broad one to determine whether they are bound by the provisions of the Bill of Rights directly. So SAA cannot turn around and say, sorry, Mr. Hoffman, we can discriminate against you because we are allowed to discriminate. The court says quite clearly that it's not competent or allowed in terms of the law. Now today, we're going to look at something a little bit more difficult. So you need to be awake, and that's why I asked you to please read the case. We're going to look at under which circumstances will the Bill of Rights bind an individual. So in other words, when can I go to court with my constitution under my arm and sue you on the basis of my constitution? When can I do that? Is it possible at all? Ever not? Okay, and then we're going to look very briefly at when and where the Bill of Rights applies, but I think the most important thing that we have to look at is when is an individual. So in other words, when can I go to court and say, you breached my constitutional right? Not the police, not the president, not the Minister of Home Affairs, but you, another individual. When can I rely directly on a constitutional right in a court of law? Okay, but let's recap, because that's always important. We distinguish between direct and indirect. What do we mean by that? Direct, constitution under your arm, you challenge, what is the source of your remedy? The Constitution. Indirect, you rely on the common law legislation. What is the source of your remedy? The common law or the legislation. But you have your spectacles on. You look at the lens, through the lens of the Constitution. You look at the common law and the legislation. So what you're trying to do is you're trying to not create an instance where there's a conflict between the law and the Constitution. But you're trying to see, is there a way in which we can read it in a compatible manner? Okay, just make sure that you have that distinction. All right, then, we've already established that the Bill of Rights always applies directly in a vertical relationship. So where there's any legislation or any legal rules that regulate the relationship between me and the state, I can always test them for validity and compatibility with the provisions of the Bill of Rights. Always that vertical relationship. But what is more problematic, and this is where we are at the moment, is the following. What do we do, and under which circumstances can we say that the Bill of Rights applies directly, horizontally to a relationship? So in other words, you and I conclude a contract, you have a will, I commit a delict. Under which circumstances can we say, actually park the common law, park the legislation, we'll just rely directly on the provisions of the Bill of Rights? Okay, so that's where we are at the moment. Does that make sense? Right. Let's dive in right into the deep end. The deep end is the text of the Constitution. A provision of the Bill of Rights, and this is the text of the Constitution, please. A provision of the Bill of Rights binds a natural or a juristic person if and to the extent that it is applicable, taking into account the nature of the right and the duty imposed by the right. Okay, let's go through that. Just step by step again. Depending on the nature of the right and the duty imposed terms of the provisions of the Bill of Rights. Okay, does that make sense? Now, once we've established that, we move to 8.3. And 8.3 then tells us how do we go about to do that. So we're going to go back to 8.2 and 8.3 over and over again, because in the first instance, we need to determine the nature of the right and the nature of the duty imposed by the right. And then after that, we can look at whether, in what way do we go about to do that, because that is what section 8.3 tells us. Okay. Now, Parry and Duval gives us an understanding and exposition, but they also, to some extent, help, but they sometimes actually make it a little more difficult. Why? Because they say, note, it does not say a right in the Bill of Rights, but it says a provision of the Bill of Rights. So in other words, they make a distinction between that which is a right and that which is a provision. Okay? So a provision can be part of a right, but not necessarily the entire right. Now here, what one has to bear in mind is that you have to look at the particular context. It is not possible for us to say, in all instances of relationships between people relating to dignity and freedom of expression, you have to look at the facts of a particular case. You have to look at the context to determine whether there is direct horizontal obligations flowing from one person in respect of another. And the second point, is actually the crux. Why was this provision enacted? Why was this provision? What is the purpose of the right as it is set out in the Constitution? Everyone has the right to freedom of movement. Everyone has the right of access to housing. What does that mean? Everyone has the right of access to basic medical care, or whatever the exact wording of the Constitution is there. But the point is that where we read a constitutional provision and we see that clearly this is enacted to place an obligation on the state to do something, the nature of that right is of such a nature that we can say it is unlikely that I would have to act on the basis, as a private individual, on the basis of the enactment. For example, if I go to a private hospital, I go to Greenacres Hospital because I have a little bit of a sniffle, or I think that I need an X-ray, or whatever the case may be. Can I go and say to Greenacres Hospital, which is at the moment run, we don't know exactly what the impact yet of the National Health Insurance will be, but let that slide for the moment. So I go to Greenacres Hospital, I say, Greenacres Hospital, I need an X-ray because I think I bumped my arm. And actually I'm relying on my section 27 right in terms of the Constitution. You have an obligation to provide me with medical care. Can it work like that? That section clearly was enacted with the purpose to place an obligation on the state. But if you look at 27.3, does anyone have a constitution here? 27, you see that. 27.3. No one may be refused emergency medical treatment. Okay? What does that mean? It means that if I arrive at Greenacres Hospital because it happens to be the closest hospital after a motor vehicle accident, Greenacres Hospital can't say, can we see your medical aid card, please? Who's going to pay? They have to treat me, but they can obviously immediately place me in a state facility if it so happens that I don't have the means to pay. They can also insist on payment for the treatment. But you may not refuse someone emergency medical treatment because you're a private individual, a company running a private hospital. So that second aspect here, take into account the purpose for which the provision. Is it broader societal interest? Or is it about an individual? Education, access to housing, social security. I can't go to you and say, I don't have a pension, it's your obligation to provide me with some social security or unemployment insurance or whatever the case may be. If there's a legislative obligation that you have to register for such, then obviously that's a different thing. But I cannot insist that you fulfill the role of the state. Okay. We have to look at the nature of the duty, and typically, where it involves money, the nature of the duty is as such that it rests on the state. But you have to look at the particular right, the nature of the particular right, the purpose and the duty that flows from it. But if it says everyone has the right not to be discriminated against, I don't think it requires any budgetary implications or any budgetary commitment from me not to discriminate against people on the basis of gender, race, sex, sexual orientation, belief, religion, birth. It doesn't require that I do anything. There's no budgetary implication. And then the last one is quite obvious when we look at the wording of the Constitution. Because Section 9(4) is very clear. No person may discriminate against another person. There is an obligation placed on you and me not to discriminate. Obviously, that constitutional provision was enacted with a view to pass legislation to give effect to that right, and that has taken the form of the Promotion of Equality, Prevention of Unfair Discrimination Act, which we will talk about later in the course. Okay, so what do we have here? We have a situation, and we will have a concrete situation, where we have to say, what is the nature of this right? Why do we have it? And does the fulfillment, respect, promotion, protection thereof require any budgetary aspects? And if so, then probably it doesn't place an obligation on the individual. But there may also be other instances, because one cannot do this in the abstract, you have to look at a particular set of facts to determine whether there is indeed a constitutional obligation flowing from the case. Now, Section 8(3) tells us how this happens. Okay, and this is interesting and a little bit confusing, but pay attention. So, I go to court. I say, you infringe my right to freedom of expression because I wanted to say nasty things and you stopped me from doing so. Okay? The court says, if we have determined that it is applicable, given the nature of the right and the nature of the duty imposed by the right, we have to ask, is there legislation giving effect to the right? So I say, you infringe upon my right to freedom of expression because you sued me for defamation because of what I published in my newspaper. Now we have to ask ourselves, is there legislation giving effect to the right as between the private persons? Is there legislation regulating the law of defamation in South Africa? That is a resounding no. We rely on the common law. Okay. If there is applicable common law, apply the common law. So first of all, you have to say, is there a way in which the law already caters for this? If the law caters for this, is that law constitutionally compatible? So then you turn to, first of all, to legislation, because you know that legislation supersedes the common law. Then we look at the common law rule, and if there is a common law rule, we apply that. And if there's no legislation or common law rule, we can develop the common law rule to give effect to the right. And we can do that subject to the limitations provision in Section 36. And that is clearly what Section 8(3) tells us to do. It says our law provides for, in many instances, for the regulation of relationships between individuals. Where there is a right that is implied or places a direct duty on someone in respect of someone else, check whether there is legislation, check whether there is the common law, develop the common law in accordance with the provisions of the Constitution to give effect to the right, and do so within the bounds of the rights and the limitations of rights provided in Section 36. Now, obviously, that may seem like a mouthful, because what does that mean in practice? Who read Kamala versus Holovisa as I asked? I've got 1, 2 takers. Anyone else? Anyone else? Who can tell me something about Kamala versus Holovisa? Let's start at the very beginning. What was the case about? This is not speech choir material. I think we will have to do individual soliloquies. I think our segments also have soliloquy categories. Anyone? Yes.
So, so this one is basically an application for you to appeal because the newspaper was arguing that the rule of the common law is not consistent with the Constitution because it doesn't require the plaintiff to say that the statement in the newspaper was false or not.
Okay. All right. So, you remember you studied the law of delict last year, a little bit of, okay? So, Holovisa sued the newspaper because he said the newspaper defamed him. The newspaper published an article to say he was involved in gangsterism and stuff. Okay? So he, citizen that he is, relies on the common law of defamation and issues a summons alleging, and for those of you who have forgotten, I can remind you, paragraphs 17, 18, 19 of the judgment. 17, 18, and 19 of the judgment tells us exactly what the common law of defamation is. Okay? So, he says they published a statement of him that is a wrongful, intentional publication of a defamatory statement regarding me. There is no requirement in the common law that the statement must be false. Okay? So if it is a defamatory statement regarding the plaintiff that was published, and you can prove that it is a defamatory statement regarding the plaintiff, it is presumed that it is unlawful and intentional. Okay? Newspaper says, we raise an exception. What is an exception again? First semester last year. You say, I'm not participating in this farce anymore. This is not a suitable, this summons of yours has no cause of action. I accept to it. Okay? So the court had to determine the matter on the basis of that exception. Okay? So it was an application to dismiss because they say there is no cause of action here. You don't have a cause of action because you never said that it was false. And the newspaper went on, and this is the important part. They said, no, can we just leave this common law business of defamation? Can we just leave it at the door? We want to rely on our right to freedom of expression, and that right to freedom of expression, Section 16, is pitted against the Section 10 right and the Section 12 right, the right to dignity and the right to privacy. If Section 12 is privacy, I think it's Section 13, now that I think about it. Okay, but it doesn't matter. The numbers are not important. So, there is a clash between two rights. We want you, court, not to bother with this common law stuff. Just leave the common. Just directly decide it on freedom of expression, dignity, clash. We are right, he's wrong, he can't get money. Okay, what does the judge say in this particular case? Let's start at the beginning. At paragraph 4 of the judgment, the exception crisply raised the question whether the common law of defamation as developed by a court is inconsistent with the Constitution. In particular, it raised the question whether, to the extent that the law of defamation does not require a plaintiff in defamation action to statement is false in any circumstances, the law limits unjustifiably the right to freedom of expression as set out in Section 16 of the Constitution. Okay, so that's the first thing. And then there's a particular part. I want you to, obviously, you need to understand the common law information. So read 17, 18, 19 very carefully. But then the judge goes on in paragraph 29 to particularly outline the issue of the horizontal application. Remember now, the newspaper said, we don't want you to engage with this common law stuff. Can we just do my Section 16 right, your Section 10 right, let's have the two rights, fight it out, and you determine who's the winner. That's what they actually wanted. The judge says, okay, let's look at this. She looks at Section 8.1 and 8.2. And she says, it is clear from Section 8.1 and 8.2 that the Constitution distinguishes between two categories of persons and institutions bound by the Bill of Rights. Section 8 binds the legislature, executive, judiciary, and all organs of state. Section 8.2, however, provides that natural and juristic persons shall be bound by the provisions of the Bill of Rights to the extent that it is applicable, taking into account the nature of the right and the nature of the duty imposed by the right. Once that has been determined, that a natural person is bound by a particular provision, Section 8.3 provides that the court must apply and, if necessary, develop a common law. She goes on to say, were the applicant's argument true, it would lead to give a purpose. It would be hard to give a purpose to Section 8.3 of the Constitution. For the effect of Section 8.1 and 8.2 read together were to be that the common law in all circumstances would fall within the direct application of the Constitution, Section 8.3 would have no purpose. We cannot adopt an interpretation that would render a provision of the Constitution to be without any apparent purpose. So she says the way in which the Constitution envisions direct horizontal application is through legislation or the common law that needs to be developed in line with the provisions of the Constitution. Okay, so what we have here is the only case, and it's 2002, where the court really unpacked Section 8.1 and 8.2 for us. Now, Makanta versus Makashule implies the direct horizontal application, but the court doesn't unpack it for us. And it also involves a political party which plays a very particular role within our constitutional democracy. But Khumalo versus Holomisa, it truly is two individuals wanting the court to say, let's just actually do this constitutional right clash. And the court says, Section 8.2 clearly says the nature of freedom of expression is very important. And our law of defamation acknowledges that. Because our law of defamation tries to strike a balance between freedom of expression and the protection of dignity and privacy. If we can see that our common law does not do that adequately to the constitutional standard, we can develop it, because that's what the Constitution provides for. But the important thing here is that you cannot bypass existing law and directly say, I want to just enforce my constitutional right against you. Okay. I can claim, and this is, in fact, giving effect to the principle of subsidiarity. We'll talk about subsidiarity in due course a little bit more. But where there is legislation or common law that gives effect to a constitutional right, we don't immediately jump to the Constitution. We always have to look, do we have a law of defamation? Is there a statute regulating it? And if that is the case, we rely on that, and if that is not constitutionally compatible, and it cannot be saved, then obviously we can challenge the validity thereof. But the important thing is, we have to rely on the law as it is, and the law must be developed in line with the provisions of the Constitution. Okay. Does that make sense? It isn't because if one would imagine, if Section 8.3 wasn't there, just Section 8, think it away, then obviously the method of direct horizontal application would not be stipulated. And then the court could say, well, actually, let's just do it. But Section 8.3 places an obligation on the court to interrogate the existing law and work within the framework of the existing law insofar as that law gives effect to the provisions of the Constitution. Okay. I want you to go and read Khumalo versus Holomisa, but read it for a particular purpose. Read it for the purpose of understanding direct horizontal application. But obviously, in the way of doing that, you have to understand the law of delict and you have to understand defamation and how it works. Because the law of defamation has very particular requirements. As long as I can prove that you published a statement that's defamatory about me, it is presumed to be unlawful and intentional. You can rebut the presumption of unlawfulness and unlawfulness in particular. Because you can say it's truth and public benefit, you can say that it was a privileged occasion, that publication was reasonable in the circumstances, that's the Bogashi defense. So you have to understand that in order to make sense of the Constitutional Court's understanding that our law of defamation actually does reflect the constitutional standard adequate. Okay, but that does not say that in all instances where I directly want to rely on my constitutional right as against you, that the court's going to agree that the law is adequate. It may be so that the court has to develop the law in accordance with the rights as set out in the Constitution and the provisions relating to limitation. Okay. Questions? Please grapple a bit with this. Great. Which then takes me to the time period for which the Bill of Rights applies. Generally, you will recall that there is a rule and a presumption against retrospective application of the law. Why? There is a general presumption and a general rule that against the retrospective application of the law. So at the moment, it says, in an urban area, you have to drive your car at 60 kilometers an hour. Okay? I drive, or not faster than 60 kilometers an hour. There's no obligation to drive at 60, although sometimes. But in any case, so there you are, driving along at 60 kilometers an hour. The traffic cop stops you, and he says, actually, the law has changed, and it will change, in fact. And you have already committed an offense because you drove at 60, and we're changing it now to 40. Can you see how that will undermine legal certainty? Because I cannot plan my life to be in line with the law. So, for example, if I drove on what is today's date? The 27th. On the 27th of July, I drove at 60 kilometers an hour. On the 1st of August, they changed the speed limit to 40. I cannot be charged with breaking the law on the 27th of July. Because on the 27th of July, I could not change my behavior. It's gone. I drove at 60 kilometers an hour. Can you understand why legal certainty and the reason that we need to be able to plan our lives and know what is expected of us in terms of the law supports this idea that the rule of law says you cannot retrospectively apply a change in the law. Both constitutions, and particularly explicitly, not particularly, explicitly apply prospectively. What do we mean by that? It means that the Constitution came into operation on the 27th of April 1994. And its coming into operation affected that which happened afterwards. But the law was in existence on the 27th of April 1994. The law that discriminated against people on the basis of race, the law that restricted movement, blah, 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 blah. The moment that constitution came into operation, that law was unconstitutional. And what the court does, and this is the doctrine of objective constitutional invalidity, the court confirms, the court doesn't make law unconstitutional. And that's a very important distinction that you have to understand. When the court says the death penalty is unconstitutional, it doesn't make the death penalty unconstitutional. It interrogates the law as it stands, and it says, we have found that the law is unconstitutional. It confirms a legal reality. Okay. So, now going back to prospective application of the Bill of Rights and talking about Mr. Makwanyane. Why could Mr. Makwanyane, who was sentenced to death in 90 or 89 or something like that, why could he rely on the provisions of the Constitution to challenge the death penalty as unconstitutional? If we say that it only applies prospectively. Because his rights were not going to be affected by the sentencing to death, but by the actual execution. The carrying out of that penalty would undermine his constitutional rights. So that was going to happen under a dispensation of constitutional democracy where this constitutional standard bound the law. And therefore the court was well within its rights and completely correct in saying that it has the authority to interrogate whether the death penalty is constitutional or not. It interrogated that, found that it was unconstitutional, declared it unconstitutional. Okay, so the doctrine of objective constitutional invalidity. Let's go back to that. And I think it always works better if you draw a bridge. So, and that case, paragraph 13 to 20, explains the doctrine very nicely and crisply. But okay. So, we have the law. We have 27.4.94. This is time. Okay, so this is time. This is the date. The law exists, the law exists, the law exists, the law exists. The Constitution comes into operation. All law that discriminated unfairly, all law that didn't comply with the standard of the Constitution became unconstitutional at this point. Now, it is 2018. I challenge the constitutional validity of a common law rule that existed since time immemorial. It became unconstitutional at that point. I only challenged it here. Okay? Automatically, that declaration of invalidity goes back to this day, unless the court regulates the declaration of invalidity. Okay? What does that mean? It means the following. Think of the case of Fourie versus Minister of Home Affairs. Okay? The case was decided, and the court found that the definition of a marriage, the common law definition of a marriage, that was given effect to through the regulations in terms of the Marriage Act, that common law definition of marriage was unconstitutional. Okay? So the court said, and this law, the Marriage Act and the regulations, it goes back to 1961. So this has been the formula for marriage since 1961. But it is common law that comes from way back when. So that definition existed. The court said, I declare it unconstitutional round about here. I suspend the declaration of invalidity, so it doesn't have an effect for a year until you pass legislation. And I think that was about 2006 or 2007. Okay. Normally, what the court would do is it would declare something unconstitutional from the date of the court order. Because if the court doesn't do that, say, for example, Parliament did not enact the Civil Union Act within the year that it had to enact the Civil Union Act. If we think of retrospective, or not retrospective, if we think of the the doctrine of objective constitutional invalidity, all marriages concluded between the 27th of the 4th of 94 and that date would be invalid, because the definition, the fundamental definition on which the law rests, is unconstitutional. So it is important that the court says it's from this day onwards that it is unconstitutional. It must regulate the declaration of invalidity. Otherwise, it will affect everything that is done in this period. Do you remember the case of Moseneke versus the master? Have you ever encountered that? Moseneke versus the master? Okay. Let's look at Moseneke versus the master. Okay. So, there was the Black Administration Act of 1927. And this act has existed and existed. The Constitution came into operation on the 27th of the 4th of 94. At that point, many of the things that were determined in terms of this act became unconstitutional. Amongst other things, the following. As part of the act and regulations under the act, if you were white, colored, or Indian, and you passed away and you had a will or not a will, it doesn't matter whether you died estate or intestate, your estate was reported to the master of the High Court, who then oversaw the distribution of assets and the tying up of the estate. If you were a black person and you died with a will, your estate were reported or was reported to the magistrate's court. And the magistrate's court oversaw the winding up and the resolution of the matters in terms of the estate. Okay. Mr. Moseneke passed away. His family challenged the validity of this distinction, this clear racial differentiation. The court found it to be unconstitutional. But it said it is unconstitutional from now onwards. Oh, no, not there. Not there. Here. Somewhere here. Because otherwise, if this becomes, remember the court confirms a fact. The court confirms the unconstitutionality of that differentiation between estates of white people and estates of black people. If the court doesn't stipulate that it is unconstitutional as from today onwards, all the estates managed between that day and this day were managed in terms of law that is invalid. Which means if you took ownership of the house of your father in terms of the law that regulated the black estate administration, and you took ownership of the house in 2000, because if the court doesn't say it is from today onwards, everything between 94 and the date of the declaration of invalidity is affected and invalid. So you took ownership of a house in terms of a law that is invalid, which means you don't have ownership of the house. Can you see that unless the court regulates the declaration of invalidity, it has serious repercussions? Because what it does is it confirms invalidity, it doesn't make it invalid. Okay. Go and read Cross-Border Transport Agency. There's the Central African Road Services, paragraph 13 or 20, where the court clearly explains the difference, or not the difference, but the importance of the doctrine of objective constitutional invalidity and how it applies. We've got 4 minutes, and I'm going to talk about the territory for which the Bill of Rights applies. So, if I go to Zimbabwe, can I claim the protection of the South African Bill of Rights? No. The Bill of Rights only applies within the territory of South Africa. And so did parties to suits learn. And that is the case of Kahuna and the case of Port Arthur. Kahuna's case involved Mark Thatcher, Simon Mann, and a whole lot of other thuggish people who were involved in the planning of a coup d'etat in Equatorial Guinea. So they were gearing themselves up to overthrow the government and they flew from South Africa, and the majority of the people who were participating, who planned to participate in this coup d'etat, were South Africans. They were stopped in Zimbabwe, in Harare, they were imprisoned, and they said, South African government, what are you doing to protect our South African constitutional rights? And the court said, nah. Because the territory for which the Bill of Rights applies is the South African territory. Obviously, as citizens, we have right to diplomatic intervention on our part by, and you always read if someone is captured by Somalian pirates or something, there's always some highbrow official involved in trying to get the person out. That's something completely different. That is the executive intervening on behalf of the person. And that is what Mr. von Abel also wanted. He don't matter. I actually quite always like to follow up and see where these people are. But he's fabulously rich. And he runs farming enterprises. And he had land in Zimbabwe and land in South Africa, South African citizen. And as part of the land reform program in Zimbabwe, he lost some of his properties. He wanted to force the South African government to intercede with the Zimbabwean government on his behalf in relation to his property rights. And the court said that's not possible. Foreign affairs and the conducting of foreign affairs is something which firmly falls within the purview of the executive. And the executive does that. And in whatever way it thinks appropriate to do so. But you cannot, through your South African Bill of Rights, and insist on the protection of your South African rights outside the territory of South Africa. Okay. But this is easy peasy lemon squeezy. I would rather you expend your energy on trying to get your head around direct horizontal and read Tomology's so carefully, and then also, very important, objective constitutional invalidity. Try to understand how this works. Because it's actually, once you have it, you can see